Minority shareholders often face insurmountable problems in requisitioning the boards to convene EGMs or extraordinary general meetings. Case in point, USP and Great Eastern recently. Singapore Exchange Regulation also recently issued a public consultation paper to prevent boards of listed companies from perpetuating undue delays in convening EGMs, especially when minority shareholders requisite these EGMs. So do the proposed new rules go far enough to fix the problems that minority shareholders face? If not, what else can be done? Because the legal and administrative things are difficult. There are huge costs involved when minority shareholders face to hold these directors accountable. We need more insights on this. Can't figure this out ourselves. Welcome to Podcast by the Business Times. I'm Howie Lim. In this episode, we speak to Robson Lee, veteran corporate and capital markets lawyer. Robson, thank you for joining us today.
Thank you, Howie.
So what do you reckon? Do you think enough's being done to enhance the effectiveness, first off, of boards? Because if not, what more then can be done? There are some things that have been proposed, like the 9-year tenure for independent board members, board diversity disclosure, etc.
Well, I think there are separate issues regarding the tenure of board members and the topical issue of minority shareholders facing insurmountable obstacles when they try to requisite extraordinary general meetings. It's principally the attitude of the incumbent board when they try to stave off or they try to block EGMs requisited by minority shareholders. While I think the Singapore Exchange has come out with a proposed set of rules which will facilitate to some extent, not enough has been done.
Okay, let's talk about, say, in light of the recent cases, Great Eastern and Sabana REIT, where companies rejected shareholder resolutions. Are there measures then in place to hold these companies accountable for their actions?
Well, I think the Singapore Exchange has proposed a set of rules. To some extent, it is to ensure that boards do not perpetually delay or hinder the convening of the EGMs by minority shareholders. But the rules are basically the listing rules of the Singapore Exchange. They do not fix a fundamental issue which would need legislative changes under the Companies Act. I cite the example of USP. I know that at that point in time, a group of minority shareholders face insurmountable difficulty because a lot of minority shareholders, their shares are held via nominee accounts of banks, for example, Citibank nominee, DBS nominee. The way the particular provision in the Companies Act is worded is that you must be a member. And a member is a term of art because when the incumbent board at that time tried to resist the EGM that was being requisitioned by minority shareholders, they applied to court to say that these shareholders are not members. And the High Court agreed because to be a member, you must either hold the shares in the listed company in scrip form or your account that hold the scripless shares are with CDP as opposed to a nominee or trustee account like Citibank trustee or Citibank nominee or UOB and so on and so forth. So to convene an EGM, you have to then either transfer all your shares in scrip form or transfer back to CDP.
So then how? You're saying for investors, the best way forward is just take the company to court?
So to fix that issue, in USP's case, the members in question then transferred their shares to CDP. And that took a long time because CDP required many documents to be provided by the company. And I knew that the shareholders in question had to go to court and got the court to direct the company to assist them so that they could transfer their shares from the nominee accounts, or they call it the sub-depository accounts, to CDP depository. So that itself is a legislative amendment that has to be made. And I do not think, therefore, the proposed changes to the listing rules would enable or facilitate that part of the difficulty that shareholders would face. That's why I said that the proposed new rules, while they go to some extent to facilitate the convening of EGMs, they do not go far enough, not to fix that particular problem that I've just spoken.
What about, say, the wave of shareholder activism and regulators' response to that?
I think regulators, particularly RegCo, which is the regulatory arm of SGX, has heard the voices of the minority. And that is the reason why they have come up with a set of proposed new rules. Basically, SGX new rules say that within 21 days, the board has to either convene the EGM or go to court and get a court direction that you do not agree with the legality or the validity of the EGM that's been requisited by minority shareholders. So now it's not a situation where the board can delay and stretch it for months and months and months and sometimes even years to frustrate minority shareholders. And unless you have someone who is very determined to ensure that the board responds to the requests of minority shareholders, many people just back off because of the cost. So that's, I think, the backdrop or the reason that for RegCo, SGX regulatory arm, to come up with the proposed changes.
Hopefully there's more to be done. You pick your brain on that in just a bit. Okay, Robson. Robson Lee is a veteran corporate and capital markets lawyer. He's giving his insights today with regard to Singapore exchange regulation and their recently issued public consultation to prevent boards of listed companies from undue delays in convening EGMs. More in a moment. Welcome back, Robson. So earlier we were talking about how not enough is what RegCo has done. What do you think then? What can be done maybe differently? And what are some of the changes you'd like to see, and from both sides? Because I don't think minority shareholders are faultless either, right?
While the proposed changes to the listing rules are very much welcome by minority shareholders, I think the legislature or the executive arm of the government has to propose changes to the Companies Act to remove the legislative obstacle where you need to be a member, or at least amend the definition of a member and allow shareholders whose shares are held in sub-depository accounts to have that right to convene, as opposed to having their shares either in scrip form or to have your shares only held directly with CDP, because most people would think of having their shares held in sub-depository accounts with nominee banks, for example. So that's something that has to be done concurrently. Otherwise, you're only fixing part of the problem.
How difficult would that be to do?
Well, I think the government needs to pass changes to the Companies Act, propose changes and have it approved and passed by Parliament. That has to be in tandem with what Singapore Exchange RegCo is proposing to amend its listing rules.
But RegCo says they're looking into it, changing the rules. What do you think?
RegCo should work very closely with the government, because it's only the government that can propose changes to the Companies Act. RegCo can only amend its own rules, listing rules. Listing rules are basically the rules that all listed companies and their directors have to adhere to in order to have the company listed on the Singapore Exchange. But they do not have that authority to touch the changes to the Companies Act itself. Then the benefit of having the listing rule in question that's proposed would then translate into facilitating minority shareholders to convene EGM. Now, I must add that Exchange, their first preference is to have matters resolved at the boardroom as opposed to the courtroom.
Of course.
And I think that's why they have highlighted in their paper, at the very first instance, when the board receives a valid requisition, they should immediately announce that to the market and then hold dialogues and talks and discussions with the disgruntled minorities to try and resolve the issue as opposed to just going to court. The exchange has also taken pains to highlight that process must not be abused to achieve some secondary purpose or some private agenda of minority shareholders. For example, to prevent the compliance with listing rules, you have a group of minority or purported minority shareholders proposing EGM to block management and the board from complying with exchange direction or listing rule. The Singapore Exchange has taken pains to then point out that in such a situation, the board should disregard such EGMs because it's not for the proper purpose. It's not in the best interest of the company.
How can you prevent that? I mean, first of all, how can you figure out that the intent is maybe nefarious? Well, maybe not nefarious, but there's a personal agenda, a personal axe to grind or whatever.
That's the reason why the proposed rules that SGX has come up with is to say that if the board feels that the proposed EGM has a secondary purpose, is not valid, is driven by personal agenda, then they should go to court within 21 days from the deposit of the requisition notice and have the court rule on whether the board should comply.
So last word, Robson, you're saying it sounds like we all have to be more litigious. Let's just go to court and get them to fix everything.
Yeah, it's not a perfect situation.
Yeah.
And that's why the exchange has, at the concluding paragraph of the proposed changes, say that whether is it a good thing to require boards to go to court to get a court ruling in order to have someone adjudge the validity or the bona fide of the notice to requisite for the EGM. There is no better forum or a body of persons who are better placed to make an objective ruling, because I think it's very well known that boards seek legal opinions that give them the justification to block EGM on some technical points, or basically to justify why they shrug off whenever they receive a requisition notice. And I think that's something that the exchange has noticed, because minorities shareholders have ventilated that basically they're using lawyers to justify their decision not to hold the EGM.
I wish we had more time, Robson, to really delve into this, but thank you for being here to talk us through it.
Thank you.
Robson Lee is a veteran corporate and capital markets lawyer. I'm Howie Lim. This has been BT Podcasts from the Business Times.